Right, good morning. I'm Simon Bourne of the Institute of International Shipping and Trade Law at Swansea University. This is the third in a series of lockdown podcasts organised by the Institute. Today's talk is on the quasi-contractual basis for granting an anti-suit injunction. I shall be looking at a recent case on this from last week, Times Trading Corporation versus National Bank of Fujairah. Decision which came out 8 days ago, and it's a decision of Mrs. Justice Cockerill. The anti-suit injunction is one of the great English legal inventions. If you break your contract by suing in a different jurisdiction from the contractually specified one, the English courts may enjoin you personally to cease and desist. If you disobey, don't even think about coming to the UK. The courts will ordinarily restrain proceedings commenced abroad in breach of a London arbitration agreement unless there is a good reason or strong reason not to do so. This is what is called the contractual basis for an anti-suit injunction, and we can look at the Angelic Grace and the Donoghue and Armco cases for establishing those principles. But the courts will still have a discretion as to whether or not to grant the injunction. Egregious delay in applying for the injunction, so that the foreign proceedings are already well advanced, is the main factor in exercising that discretion, so as not to grant the requested injunction. The courts may also issue an anti-suit injunction in respect of non-contractual proceedings commenced in a foreign jurisdiction. Here, the bar is much higher. The party seeking the injunction needs to satisfy the court that the foreign proceedings are vexatious and oppressive, which requires the court to be satisfied that England is clearly the more appropriate forum for the trial of the action. And that's sometimes referred to as the natural forum, and that it is necessary in the interests of justice to grant the injunction, taking into account considerations of comity. Again, the usual caveats apply as regards discretion and delay. There are, however, cases which fall in between these two stools, what the author Raphael, in his book on ASIs, has referred to as the quasi-contractual basis. One such case is Times Trading Corporation versus National Bank of Fujairah. A straightforward misdelivery claim brought by a bank, National Bank of Fujairah, NBF, against the bill of lading carrier, or so it would seem. The problem was the possibility that there was a demise charter in play, in which case the contractual claim under the bill of lading would be against the demise charter, not the registered owner. Security was given by the charterer, Trafigura, who then entered into a cooperation agreement with the registered owner, and also with the demise charter of Times, under which Trafigura would see to the handling of the claim. The bank had issued a writ in rem in the Singapore courts against the owners and against the demise charterers, although their position was that the demise charter was a sham and the carrier was in fact the registered owner. They also commenced arbitration proceedings before the expiry of the one-year time limit in London, but this time the notice of arbitration was addressed to the registered owners, Rosalind, care of Times. Subsequently, the Singapore writ was served. Eventually, NBF obtained a copy of the demise charter. In March 2020, Times applied for an anti-suit injunction to restrain further proceedings in Singapore, praying in aid the London arbitration clause in the bill of lading, and at long last disclosing the copy of the demise charter. So how do we classify this type of ASI application? Contractual, quasi-contractual, and if quasi-contractual, what principles govern? The quasi-contractual argument was based on the bank's point that there was an issue as to who was the carrier, and in those circumstances the court could not be satisfied that there was an arbitration clause between these two parties. Mrs. Justice Cockerill identified two categories of quasi-contractual ASIs. First, the quasi-contractual stroke-derived rights category. This is where the existence of the contract is not in doubt, but the person bringing the foreign proceedings is not a direct party to that contract. For example, they may be suing a P&I insurer under a direct action statute in the foreign jurisdiction. In doing so, they will have to take the rough with the smooth in jumping onto the assured's contract with his club. And that means respecting the London arbitration clause in that contract. This was the case in the Yusuf Setnioglu back in 2016. Second, there are inconsistent contractual claims, where the person sued in the foreign proceedings says there is no contract, but the person suing them, in effect, seeks to make a claim under the contract while not seeking to respect the forum clause, which forms part of it, having your cake and eating it. An example is provided by Huingdao Huiquan versus SDHX, a case from last year. A settlement agreement containing a London arbitration clause had been reached between the ship owners and the cargo receivers. Sums were to be paid to the owners by SDHX, the receiver's authorised agent. SDHX then sued the owners in China, seeking repayment under the settlement agreement. Owners sought and obtained an anti-suit injunction. The basis of SDHX's claim was the settlement agreement, and they were stuck with the arbitration agreement in it. There are two apparently divergent approaches to granting an ASI in a quasi-contractual case. In the use of Setnioglu, Lord Justice Longmore said that the angelic grace principles applied quasi-contractually by analogy, while Lord Justice Morbick adopted an analysis of vexation and impression, but with the inconsistent claims giving rise to a strong factor militating in favour of finding vexation. However, it seems that all roads lead to Rome, in this case Rome being the application of the angelic grace by analogy. Now, the current case, in Times versus MBF, was not directly analogous to either of these two categories, but in essence it was a quasi-contractual one, and the angelic grace principles will apply. The bank had adopted a somewhat Janus-based approach. It denied the contract, but it had also brought in rem proceedings against both Times and the registered owner in Singapore. Indeed, the present case seemed to be a contractual one, and that would be common ground whether a bareboat charter. The bank, NBF, however, had argued against this due to the dispute as to the reality of the charter, which meant, according to them, that the relevant high standard of proof of the contract and hence the operative arbitration clause could not be met. However, Mrs. Justice Cockerill was of the view that this hurdle had been surmounted. First, there was in existence a document that appeared to be a bareboat charter to Times. Second, there was the existence of a claims handling agreement which predated the one-year time bar, which named Times as one of the parties as bareboat charterer. And third, MBF had itself sued Times in Singapore asserting a contract. So, it looks like a victory for Times. But what about the matter of discretion? The possibility of a time bar being raised in any London arbitration by Times against MBF was not enough to constitute strong reasons for the injunction not to be granted. However, the general conduct of the case, while not showing egregious delay, did disclose elements of delay which informed the court's discretion. Bearing that in mind, the anti-suit injunction was granted on condition that Times undertook not to rely on any time bar in the London arbitration. Interestingly enough, that's exactly what the bank had proposed back in February of this year, and Times hadn't been that interested in agreeing to that proposal. So, thank you for your attention. That's the end of today's talk. There will be further talks in this series, and the next one will be sometime next week. Goodbye.